Good evening, sir. Good evening, sir.
Hello, good evening.
Good evening, sir.
Good evening.
Good
How are
evening.
we?
We are fine.
So what's happening now? Are we having lecture or we are just... Well, I can't hear anything. I really need to be sure that...
Honestly, the host is already here. I don't know whether it's not connected.
Yeah.
I've been here. It's almost 6:30 now.
Yes, so we need to do some other things, though, if the lecture is not going to take place.
Hello?
Hello, sir.
Can you hear me now?
Yes.
Oh, okay. I think I needed to unmute before. So I was talking, you people were not hearing me. How many of you are in class? You are interested in this course? Is this the number? I can see only 4 students. Dima, Aisha, Olabode, Augustine, Francis, Chitima, Omanofe. Is that the size of the class?
Most of them they are offering the courses, sir. Some of the students are not offering the course, sir.
I know it doesn't have to be everybody. I just want to be sure. But is there no way for us to know how many people registered for the course?
Maybe at times, when the lecture progresses, we will know, sir. We will not know now.
Okay. Now, I'm expecting some other people to join us in the LL.M cyberspace law program for the course called Dispute Resolution. Okay? So I've just sent the link. It is because of them that I tarried in starting the class. I was to start the class by 6, but because of them, I tarried a little. But I've sent the link to them now. And okay, their class captain is acknowledging receipt of the link and may join anytime. But at the risk of repeating everything I will say before they start joining, let me not waste your time and let's talk about the course generally. Okay?
Okay, sir.
For the mind people, the title of the course is International Civil Litigation. International Civil Litigation. In the LL.M class and the LLB class, we call it conflict of laws. We call it conflict of laws. So conflict of laws is virtually the same thing as international civil litigation. And what is international civil litigation? Is civil litigation, for those of you who have some knowledge of law, we divide liability into civil and criminal. Civil and criminal. Okay? In the civil litigation, yes, the people from cyberspace are already joining. In the civil litigation, you have private persons trying to resolve their dispute through the courts. A party files an originating process. It may be called a writ of summons, it may be a petition, it may be an originating summons, it may be an originating notice of motion, and what have you. And you get it served on the other party. And like a football game, you see all of them, you see both plaintiff and defendant presenting their case in court. One party will win, the other party will lose. Okay? That is the nature of a civil case. Sorry, the cyberspace people, I'm going to this level of introduction because our mind students need not have background of law. On the other hand, the one you call criminal liability, it is the state or an agency of the state that is prosecuting a person for committing a wrong that is known as crime. For a wrong to be criminal, the first requirement is that a statute must prescribe it to be so. And the second requirement is that the statute must impose penalty. Penalty will come in form of either imprisonment or fine or other form of punishment known to penal legislation. So the important thing about criminal liability is that some authority or agency on behalf of the state will prosecute the wrongdoer. Okay? There are other details of distinction that exist, but we don't need to dive into them. So when we say international civil litigation, we are talking about the civil case, that is the plaintiff versus defendant case in court that is international in nature. What makes a civil case international? What makes a civil case international? What makes a civil case international is when foreign element is involved. Foreign elements. What do we mean by foreign element? If A sues B in Nigerian court, both A and B being Nigerians living in Nigeria, there will be no foreign elements. There will be no foreign elements. Everything about the case will be Nigeria. So you are not likely to have a challenge to court jurisdiction on the basis of propriety of venue. Okay? You are not likely to have a law other than Nigerian law being the governing law of the dispute. And you may not need to enforce the judgment that the final court will give outside of Nigeria. So everything about that civil dispute is local. it is not international civil litigation then. But if litigation will become international in any of three circumstances. One, if there will be dispute about propriety of venue. For example, one of the parties is saying, why are you bringing me to Nigeria for transactions that were conducted or contracted in statewide? So that's how you begin to know, yes, this dispute is international. Okay? There could also be the question of which law will govern the dispute. It is not compulsory that Nigeria and statewide law will be the same. And so you could have one of the parties saying, why will you be applying Nigerian law to a dispute that is basically a statewide located dispute? Then, if the case goes on in Nigeria, Nigeria may not be its first stop. Since the case has connection with statewide, you might also need to enforce the judgment in statewide. It could also be that it was in statewide that the case was commenced. Okay? But the asset of the judgment debtor is in Nigeria. So that judgment obtained in statewide may not end in statewide. It may become necessary for the judgment creditor to come to Nigeria, get the support of Nigerian judiciary in order to give effect to it. So that is why we call those type of disputes international civil litigation. Okay? Or we call them dispute under private international law. Okay? For the cyberspace group, why do you need to know the rules of this subject area? The answer is very simple. Because in your subject area, you are training to become experts in giving solution to relationships that are formed online. And one of the things that such relationships do not have respect for is territory. I can sit down here in my house and enter into a contract with somebody in US. Okay? Do you imagine what will happen if we have a dispute related to that contract? Definitely, we will have to interrogate private international law. So, whereas private international law, international civil litigation can possibly be avoided in the era when everything was conducted on a face-to-face basis, where you would have a venue that you could specifically call the venue of the contract, with the assumption that it is the law operating in that venue that will be the governing law. Okay? In that era, maybe someone could readily avoid private international law or international civil litigation. But The moment the internet started bringing people together in relationship and contract and what have you, this subject becomes a must-know for you to really truly be an expert in the area of civil cyber relations between two or more persons. So that's a brief introduction. In an LLB class, we don't even make it this simple. We just tell them that this subject called conflict of laws or private international law becomes needed or becomes the solution whenever a civil dispute has a foreign element. And we will go ahead to explain what foreign element mean using different examples. We say, for example, contracts. A contract can have foreign elements because the parties are amenable to different legal systems. And so they will have to resolve the issue of which of the legal systems that they are amenable to, or even the one that they are not amenable to, that should govern their disputes in the event of one arising. So different countries will then come with different formula. Some countries might say, okay, apply lex loci contractus, law of the place of contracts. Others may say, apply lex loci solutionis. If the contract involves doing something, apply the law of the place where that thing will be done. That's what is called lex loci solutionis. Okay? But the modern position is that, well, contract is an exhibition of freedom by two or more persons to legislate for themselves. It is their own terms that the law helps them to enforce. So if we recognize that what they are simply doing is making law to themselves, then if they come from different legal systems, they should have the right to dictate under which law they are making their contract or which law will govern their contract. So most countries today will use what is called proper law of the contract as the test for determining the law that will govern a contract between a cross-border contract, in short, between persons who are living in different territories. You can use also torts as an example. Torts are civil wrongs, usually identified by law and for which victims are entitled to damages and assailants are supposed to pay damages. Okay? A tort could be international. For example, you can write here in Nigeria, publish a defamatory statement about someone abroad. Okay? So that tort is international in nature. You can also commit physical wrongs, but the injury of your physical wrong might be suffered in another state. For example, somebody could shoot a gun in a border town, and the bullet could go and hit someone in the territory of another country. So, which law should determine liability? Is it the law of the country where the gun was shot, or the law of the country where the bullet pierced somebody's body? So that's how it could happen. Okay? What of marriage? Marriage is a status relationship. What do we mean by status relationship? Status relationship are relationship where parties would enter into what is known as a contract, but they will not be in control of the terms. They will enter into what is known, for example, two persons marrying themselves will be governed by already stated laws governing their marriage. The only aspect where they play a role is they are seeing each other and agreeing to marry. So they take the terms or leave it. If you take it or leave it arrangement, they cannot. We used to crack a joke of a man who married a woman, and in their first night, they say, let's decide the detailed terms of this relationship. And so the husband was to ask the wife, adultery is a no-go area. Okay? If the husband was to say to the wife, adultery is a no-go area. If you commit adultery, the marriage terminates and you leave the house. So the wife also asked, I agree that adultery is a no-go area. Okay? If you commit adultery, that is the wife telling the husband, if you commit the adultery, what happens? And then the husband tells her that, you also have a right to deem the marriage as terminated and to leave the house. And so the wife was saying, it doesn't mean that I'm the one who is suffering. Whether it is you or I who commit adultery, I will be the one who is suffering. I commit adultery, I leave the house. You commit adultery, I leave the house. So the bottom line is that they are going beyond their boundary, because the system of law under which they marry already has the I is dotted and the T is crossed as far as the consequences of adultery is concerned. What they should have familiarized themselves with is what that law says. Now, if A and B are marrying in the same state, governed by the same law, it is the law of that state that they will be looking at. But what of if the marriage is internationalized? If a person who is governed by the law of state A marries a person who is governed by the law of state B, which law are they going to study as the bedrock of the terms of their relationship? There's going to be a choice of law problem, because persons who are amenable to different countries' laws are the ones marrying. So conflict of laws will then come and say, look, it will depend on the question relating to the marriage that they are trying to resolve. If one of them is trying to nullify the marriage on the basis that it was not formally done, then you apply the law of the place of celebration, the law of the place of marriage. But if it has to do with capacity, like such things as prohibited limit of affinity, prohibited limit of consanguinity, uh, age, etc., you know that countries have different marriage age. There are some countries where at 14 or 15, they're already old enough to marry. There are others where you have to be 18 or 21. So if somebody is from a country where he is not qualified to marry until he attains 18, but goes to the country of someone whose law permits people to marry them at the age of 15, and he was doing the marriage at the age of 17, what will we call that marriage? Are we going to judge the marriage by the prescription as to age of the law of the husband or the law of the wife, or are we going to subject the marriage to both laws? That's what you call antenuptial domicile. If A marries B, B must satisfy A's law and B's law. A must satisfy B's law and A's law. That's antenuptial domicile. And you have the one you call matrimonial home domicile, which is looking at the husband's place, their home. It's an assumption that their marriage is going to be into the husband's locality. So in that event, you want to say it is the law of the husband locality that matters, all of that. So those are the different scenarios, okay? So in summary, what are the 3 questions that this subject area answers? What are the 3 questions that this subject area answers? The questions are really never more than 3. For emphasis sake, we might mention other things, but the questions are always 3. The first question that civil litigation or private international law answers is what we call choice of jurisdiction. Choice of jurisdiction, by which we mean venue of litigation. Venue of litigation. Which venue is proper for litigation? If A and B, living far wide apart, thousands of kilometers apart, enter into contract online, should there be a need to litigate their disagreement in a territorial space? Where will they go? That's choice of jurisdiction. Okay? That's choice of jurisdiction. Even if they do not do it online, if there are people living in different places, even if they met in one place to do it, okay, when dispute arises, they may not all be in that place when the dispute would arise. They may have done the agreement in a third place. And by the time dispute will arise, either of them might be in their respective territory, which is different from the third state. Must it be that they will go to the venue where they contracted? Would it be correct for the defendant, for the plaintiff to commence litigation in his own place and drag the defendant from his own place to come and attend to court? Or should the plaintiff go to the defendant's place and file an action? That's what we call choice of jurisdiction. So that's the first question we answer in this subject area. The second question we answer, and this second question is independent of the first. Those who do not know this subject area would assume that once you answer the first question, you don't need to answer the second. So what is this second question that you always need to answer if there's a foreign element or there's a relationship formed between persons amenable to different legal systems? The second question is what we call choice of law. Choice of law. The civil dispute will have to be resolved according to a state law. And here we are. We have on our hand a dispute involving people amenable to different state laws. So, choice of law simply answers the question, which of the alternative state laws would you use to govern the dispute? The difference between state laws can be very significant. You might want to claim a head of liability that one state law recognizes, the other doesn't. You might want to seek a relief that the public policy of one state law does not permit you to seek, but the other does. So it is very important which will be the governing law of your relationship. So that's choice of law question. The common mistake in this area, especially for those who don't know this subject area, is that they would assume that once you are litigating an international civil dispute in statewide court must apply statewide law. In a sense, they are correct, but it needs explanation. Statewide law would also include statewide choice of law rules. And statewide choice of law rules might oblige statewide courts to apply foreign law. So in a way, you can say that in that type of situation, statewide court is applying the whole of statewide law, including our choice of law rules. Though at the end of the day, they may be the rules of another country, but they have incorporated by reference because statewide complete law includes a choice of law rules. And once a choice of law rules direct our court to apply a foreign law, that foreign law is being applied as if statewide court is applying statewide law. So that is the second question. The third issue that would always arise, I've explained it before, is called enforcement of foreign judgments. Enforcement, recognition and enforcement of foreign judgment. Recognition and enforcement of foreign judgment. As we stated, one of the parties might have ended up obtaining judgment in one of the alternative states. if the assets of the judgment debtor is in that state, then there will be no need for him to sorry. Thank you. Mr. Mitope for cyberspace. How many of your members have joined this class? I have 22 members. And I want to be sure that I want to know the ratio. Hello?
Good evening, sir.
Good evening.
Yes, sir. So about 18 of us have joined the class, sir.
A couple of you from the cyberspace group. I think
Yes, sir.
24 people joined.
Sir? What did
There
you say,
are
sir?
people, apart from myself and the host, there are 24 others.
Yes,
I
sir.
just want to be sure the ratio between my and the cyberspace.
Yes, sir.
Do you have an idea of the size of your class?
Not yet, sir.
Can you help me find out?
I will do that, sir.
Okay. I don't even think the might people have a class cap. So somebody should take position and help me find out the number of my street doing international litigation. Okay? So in order for us to move fast, I have a textbook on this yet. Go to the department and buy a copy. Don't take it for free. Go to the department, buy a copy, as of Mr. Paul, so that we can make a step progress in, say, between 6 and 7 meetings in random class. Okay? There are some topics that will be peculiar to cyberspace. There are some topics that will be peculiar to cyberspace. What I will do after we have discussed the general civil litigation topic is to do maybe 1 or 2 extra lectures for the cyberspace food and solution people. So the next issue I want to resolve is how will we be doing our lecture? Never now, all of say, virtual, you don't want to think like, don't say that the rule allow completely virtual class. So we have to be mix them. Then by the grace of God, we will do physical. And so we are able to physically meet ourselves. We can determine how often we're going to be doing virtual assist and how often we're going to be doing physical class. So that day the class is much late. The time for lecture is 5 o'clock to 7 o'clock. I tend to be in class not later than 15 minutes from today, whether physical or virtual. So those the impression that please civil litigation, please put resolution. The letter won't be class until 6:30 that started today. That's not correct. I'm not an easy lecture. You can be rest assured that whether we are doing virtual or doing physical, I will only give you 15 minutes to sort your settle class before I join. So on note, we shall try to meet ourselves next Thursday and go to out for the 2 courses, which largely the same, only that the first space would have 1, 2 peculiar topics, which we would have talked about them as we are going, but we emphasize them later after we have discharged the civil litigation class. So thank you very much for attendance. I see you next week. Any question, comment? I assume they are on. So see you next week. You're welcome.
Thank you, sir.
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 Good night, sir.